extrajudicial expenses of payment are for the account of the debtor, because it is her responsibility to fulfill her obligation. And under the rules of court, losing party generally pays for judicial cost. This is my example. Krista is the owner of the apartment, entered into a lease agreement with Marceli for the amount of $5,000 to be paid every third of the month. However, Marceli failed to make the payment for 4 months. Despite oral demands, Krista wishes to have Marceli vacate the property and collect the unpaid rental fee. She then seeks the service of attorney Salvani and a fee of $6,000. 2 demand letters were sent via registered mail and incurred $350 for such letter on Marceli. Forwarded her intent to vacate the apartment and make the payment for debt, which shall include the unpaid rentals and expenses incurred upon hiring legal service.
Article 1248. Unless there is an express stipulation to that effect, the creditor cannot be compelled partially to receive the prestations in which the obligation consists. Neither may the debtor be required to make partial payments. However, when the debt is in part liquidated and in part unliquidated, the creditor may demand and the debtor may effect the payment of the former without waiting for the liquidation of the latter. This article gives the right for the creditors to refuse partial delivery of payment from the debtor. Partial performance is not allowed under this article unless it is required or insisted. Somehow, it takes into consideration some aspects or conditions that the debt is subjected to, such as installment basis, only if it meets the specific requirements indicated in the provisions of this article. Unless it is expressly stipulated that the creditor or debtor can accept or deliver partial payments, or the debt is partly liquidated, or prestations are subject to different terms and conditions, such that they cannot execute it simultaneously. Both parties cannot be compelled to pay or demand partial fulfillment of the obligation. For example, Graciela is indebted to Zarni for 500 pesos due today. Graciela cannot compel Zarni to receive 300 pesos in partial payment of the obligations, and neither can Zarni require Graciela to pay only 300 pesos unless there is an agreement to the contrary. So in this problem, partial performance is allowed if Graciela would pay 300 pesos due today and promise to pay the remaining 200 pesos tomorrow with the agreement of both parties, and then obligation can be complied partially.
Article 1249. The payments of debts in money shall be made in the currency stipulated, and if it's not possible to deliver such as currency, then the currency which is a legal tender in the Philippines, the delivery of promissory notes payable to order, or bills of exchange, or other merchant documents shall proceed the effect of payment only when they have been cashed, or when they to the default creditor they have been impaired.
Article 1250 state that in case of extraordinary inflation or depletion of the currency stipulated should supervene, the value of the currency at the time of the establishment of the obligation shall be the basis of payment unless there is an agreement to the contrary. Extraordinary inflation or depletion refer to the decrease or increase of the purchasing power of the currency of a country, the Philippine peso, which is unusual or beyond the common fluctuation in the value of the said currency. In case of extraordinary inflation or depletion, the basis of payment under Article 1250 will be the purchasing value of the currency at the time of the establishment of the obligation. Example, if the price of oil goes from $75 a barrel to $100 a barrel, input prices for the business will increase and transportation costs for everyone will also increase. This may cause many other prices to rise in response. There is no agreement between the two in case of possible extraordinary inflation or deflation that might occur. The basis of payment shall be the equivalent of the purchasing value of the currency at the time for the establishment of the obligation. The legal role in Article 1 to 50 considers contractual obligation where a currency is selected by the parties as the medium of payment. It does not only apply where the obligation to pay arises from a source independent of contract or agreement.
Article 5.1 Payment shall be made in the place decided in obligations, there being no express stipulation in the undertaking is no deliver a determined thing, the payment shall be made wherever. The thing might be in a moment the obligation was consummated. In any other case, the place of payment shall be the disciples of the debtor, and the debtor changed his disciples in bad faith or after he has declared in daily the personal expenses shall be borne him. Their provisions are without reduce to renew under the rules of the court.
Article 1252. He who has various debts of the same kind in favor of one and the same creditor may declare at the same time of making the payment to which of them the same must be applied, unless the parties so stipulate, or when the application of payment is made by the party for whose benefit the term has been constituted. Application shall not be made as to debt which are not yet due. If the debtor accepts from the creditor a receipt in which as application of the payment is made, the former cannot complain of the same unless there is a cause for invalidating the contract.
Article 1253. If the debt produces interest, payment of the principal shall not be deemed to have been made until the interest have been covered. Example: Jimwell owes Jessa 5,000 pesos with 1,000 pesos as accrued interest. Jimwell pays Jessa 5,000 pesos. The 5,000 pesos will first be applied to the interest earned by the debt. Then the balance of 4,000 pesos will be credited to the principal amount. Therefore, Jimwell will still owe Jessa 1,000 pesos of the principal